The next matter to come before the court this morning is State of Ohio versus Paul Chike. Thank you. The appellant has not, the appellee has not filed a brief in this case. You have 15 minutes. Counsel, we've read the brief. We're ready to see when you are.
Thank you. Good morning, Your Honors. May it please the Court, Mary Solanska on behalf of Appellant, the State of Ohio. Your Honors, this matter involves a defendant who was sentenced on two separate cases. They were unrelated, both involving felonies of the second degree, which gives the state the right to appeal the judicial release. The standard of review that the court needs to apply, as I'm sure you're aware, is a de novo standard of review. In this case, pursuant to Revised Code Section 292920C4, a defendant who's sentenced to more than 5 years in prison but not 10 years is eligible for judicial release after he serves 5 years. The question in this case that the court has to answer is whether the trial court erred in granting judicial release approximately 10 months before what the state asserts was the defendant's eligibility. He was transported to the institution and would not have served 5 years until January 5th of 2015, but he filed his motion for judicial release on March 13th, 2014. I've cited a case, State v. Strunk from the 12th District Court of Appeals, that has held that an aggregate sentence for purposes of the non-mandatory prison term in the 292920 includes a sentence that is imposed for multiple unrelated cases at a single sentencing hearing. It was, interestingly, the only case I really found that was on point or that had addressed the issue. So what happened was the defendant had two cases. He was brought before the court for sentencing after having pled guilty to negotiated pleas, and the trial court sentenced him to an aggregate sentence of 8 years, 4 years on each case. So arguably, if the court were to treat each sentence separately, then he could file for judicial release. I think it's after 6 months if it's a sentence of less than 5 years, which would mean on each case it would be 6 months. But he would have to be granted judicial release on one and then serve 6 more months and be granted judicial release on the second one before he could get out. So I don't think that that's what the purpose of the legislature was. We have to look at the purposes and principles of sentencing. And in this case, the trial court was looking at a defendant who had multiple cases, and he imposed a sentence at one hearing considering all of the sentencing factors, and he determined that the defendant should serve a total of 8 years on those two cases. Based on that, I think that the analysis in Strunk is applicable in this case. I think it's a well-reasoned opinion that a non-mandatory prison term, when it's imposed at one sentencing hearing, that means that the court is taking into consideration all of the factors and the fact that there were two separate cases. Based on that, the state asserts that the trial court erred in granting judicial release in this case on a motion that was filed before the defendant was even eligible to file for judicial release. I think that the factor that it was at one sentencing hearing comes into play because when the court is imposing that sentence, it's determining that based on both of those factors, and I'm sure aware of what the criteria for eligibility for judicial release is saying, I'm giving you 8 years. I think that the court has to be held to that when they do that at a sentencing hearing. The analysis in Strunk, I think, is applicable. In that case, the defendant was sentenced on two separate cases, and the 12th District Court of Appeals held that it was an aggregate sentence for purposes of the judicial release statute. And I asked that the court would impose that reasoning in this case and reverse and remand the decision to the trial court. The defendant obviously would now be eligible for judicial release and could apply for it, but given the time that he's been out, actually, let me retract that statement, we'd have to kind of do the calculations, and determine whether he had served the time. I think because he was released before, I didn't write down the date he was released, I apologize, but it was a few months after the March motion. So he might still have maybe 6 months or so to serve before he would even be eligible to apply for judicial release. We ask that the court apply the de novo standard of review and adopt the reasoning that was used by the 12th District Court of Appeals in Strunk and reverse the decision of the trial court and remand this case. If there are no
Thank you for your presentation this morning. The court will take a matter under advisement, issue a written decision, which will be mailed to both sites and posted on our website. Thank you very much.
Thank you.